sometimes we use a few words that contradict each other, like just because you're guilty doesn't mean you did it. And in this case, we're gonna talk about just because it's legal doesn't mean it's necessarily a good law. And just because it's legal for a little while doesn't mean that law won't be thrown out later. This happens more than you might think, that something that becomes law later is no longer the law. It gets overturned, it gets thrown out. It's not a legal law. Currently, a Florida law that is what we call on the outer limits of constitutionality. This is not my words. The actual court in McClama v. State says that this law that we're going to talk about is on the outer limits of constitutionality. Let me tell you what happened in McClama. So this old lady lives in a trailer park, and she lives with a whole bunch of other seniors in this trailer park. And late at night, she sees this teenage black, tall, thin male with no shirt on roaming between some of the trailers. She gets concerned. She calls the police. She says, this is a little strange given who lives in here. And the cops are like, well, are there any problems? And they're like, no, there aren't any problems. We don't have any burglaries. We got no shenanigans in here, but can you come out and check it out? The cops come out and check it out, and they don't see this light-skinned black teenager that she described, but they get on their radios like they often do, and they say, hey, be on the lookout. We got a bolo for a tall, thin, shirtless teenager. And this is late at night. Now, some other cop 30 minutes later sees, he's just chilling in his car. He sees a tall, thin teenager with no shirt on run from a house into a taxi. But the one thing I'm leaving out, folks, is that this kid is white, not black. But nonetheless, the cop says, I thought I heard something half an hour ago about a tall, thin, shirtless teenager. I'm gonna stop this taxi. And that's exactly what he did. He stopped the taxi. Now, it turns out inside McClama is the tall, white, thin teenager shirtless in the taxi. Turns out McClama has a backpack with hydrocodone in it and a bunch of other stuff, and McClama gets a trafficking and hydrocodone, possession of controlled substance. McClama even admits to burglarizing a bunch of cars in the area, so he gets burglaries of a conveyance. I mean, the kid is in deep trouble, and he gets convicted of everything. His attorneys, rightfully so, file a motion to suppress. That is a fancy way of saying, Judge, none of this evidence should come in. The case should be dropped with no evidence because this kid never should have been stopped in this taxi. This stop was a bad stop. Now, the prosecutor said, oh no, this was a great stop because we were investigating a loitering and prowling misdemeanor. And when we investigate a loitering and prowling misdemeanor, we get to make this kind of stop. Let's explain to you what a loitering and prowling misdemeanor really is, because the court says it is on the outer limits of constitutionality. The crime of loitering and prowling is the creation of alarm in the observer cop. The cop has to observe something that creates alarm. And here's what they said. To commit the crime of loitering and prowling, the officer is determining whether he or she is viewing live conduct that reasonably causes alarm in the officer or an immediate concern that person or property will damage or harm to person or property will likely occur in the very near future unless the officer intercedes. Once a person is stopped for loitering and prowling, the court says, the person must be allowed to give a statement to dispel alarm or immediate concern. As explained earlier, the Supreme Court actually says that this is a defense and it is a requirement that law enforcement ask, hey, what are you doing? Identify yourself before they just put handcuffs on you because something looks weird. This whole situation, the court says, this defense is a little unusual because the crime has already occurred because the officer has already been alarmed and has already taken at least some of the steps necessary to prevent the damage by interceding. The officer is interceding and giving you a loitering and prowling before you commit some harm to somebody or somebody else. Here's an example of how this works. Here's the hypothetical that the court gives. Let's say that an elderly woman loves flowers that she's planted beside her old wooden home. And the local government has a watering ban in place. We don't have any water. You can't water your flowers, but she loves her flowers. So she doesn't want anybody to know that she's watering her flowers illegally because there's a ban on watering right now. She wants them to survive. So in the cool of the evening, when it's dark out and nobody's watching, she gets on a hoodie, she disguises herself, and rather than looking like she's watering with like a flower waterer, she actually gets a gas can and she puts water in the gas can, and now she's watering her flowers secretly. Well, guess what happens? A cop sees this and says, this person is committing loitering and prowling because she is about to burn down this house and commit arson by using all this gas and going around the skirt of the house with this gasoline. The cop has to, according to the loitering and prowling law, has to approach this woman and ask her, what's going on here? Identify yourself, what are you doing? And that is how a loitering and prowling can work if it's constitutional and it's legal. So let's get back to McClama. What is going on with McClama? Well, the court threw out the drug trafficking and the burglary charges. The court threw out all of McClama's crimes because the court said, look, this investigation for loitering and prowling of this kid inside a taxi does not follow the loitering and prowling law, which requires the officer to see something and intercede on a crime about to happen. Nothing like that happened. You had an old lady in a trailer park describe a young teenage black male that wasn't even committing a crime. Even that teenager probably could not be arrested for loitering and prowling, much less McClama, who was not seen by the officer doing anything other than running from a home into a taxi. Bam, drug trafficking thrown out, multiple burglaries to a car thrown out. Loitering and prowling, folks, is just barely legal. And the McClama case and many others kind of discuss how rigid and how structured a arrest and conviction for loitering and prowling must be if it's going to withstand any sort of legal scrutiny. So there you have it.